it out. All right, outside the presence of the jury at the close of the state's evidence, I'll entertain any motions at this time. Mr. Arbor?
Yes, Your Honor. Thank you. Respectfully, the defense will remove for a mistrial for all the grounds previously stated on the record. We won't re-articulate the grounds unless the court requests that they be re-articulated.
No, sir.
And just summarize that we essentially based our motion for any mistrial of this manner on the denial of a fair trial to Mr. Broyhill and a denial of his rights under the 5th, 6th, and 14th Amendments to the Constitution of the United States.
All right, that motion is denied.
Thank you, Your Honor. Respectfully, then, the defense would move to dismiss the charge of murder in the first degree with respect to the indictment involving Ms. Hahn and submit to the jury only the charge of murder in the second degree. The basis for our motion, Your Honor, is that no credible evidence exists, even that all of the evidence presented by the state, even looking at it in a light most favorable to the state, that would suggest that there was any premeditation or deliberation on the part of Mr. Broyhill, or that it was committed as part of a felony or a continuous transaction of a felony, and that includes with the alleged, with the knife attack on Mr. Hahn. And therefore we move to dismiss the charge of murder in the first degree. We do not object to the submission of murder in the second degree being submitted to the jury for their consideration.
All right.
No other motions with respect to the indictments involving Mr. Hahn.
Yep. Mr. Hahn as
Correct.
well? All right, so that's the sole motion to dismiss. That motion is also denied.
Okay.
All right. Any other motions?
No, maybe I misunderstood. The first one was with respect to Ms. Hahn.
Yes.
And then there is no motion with respect to Mr. Hahn.
Yes, that's how I understood you. So there, you have one motion to dismiss. It relates to the indictment relating to Mrs. Hahn.
That's
yes,
correct.
Sir. All right, and that motion is dismissed.
That's correct.
All right. Very well. Any other motions that you have for the court at this time?
No other motions at this time, Your Honor. The defense will be presenting evidence in this case, and I believe before the break, Your Honor wanted to Your Honor wanted to conduct a hearing, I think, again with Mr. Broyhill regarding the decision of us to put a defense in, and where I'm thrown off a little bit. I can do this now, or we can do it afterwards with respect to The witnesses that we identified for you earlier are available. We tend to go forward with them. There are 2 witnesses for this afternoon. Beyond those 2 witnesses, we do not have any other witnesses for today. And would ask that, should we finish those 2 witnesses before the normal ending of business, we would ask that Your Honor break court for that at that time and then continue on to the next day.
All right. Yes, sir.
That was the only scheduling thing.
Yes, sir. We can accommodate that. Yes, and I would like to speak with Mr. Broyhill regarding his decision on whether he will testify. Mr. Broyhill, I want to talk with you about a decision that you need to make. This is a personal decision, one that you alone must ultimately make. You should consult with your attorney about this decision, and you should listen very carefully to their advice, but ultimately it is a personal decision that you must make, and that decision is whether you will testify. If you do choose to testify, there is a consequence of that decision to testify, namely you'll be waiving your privilege against self-incrimination. And what that means is that if you choose to testify, you'll be required to answer truthfully the questions posed to you by your counsel, as well as the questions posed to you by Mr. Fawcett on behalf of the state. So I want to make sure that you understand that consequence and that you've had an opportunity to fully discuss that with your counsel and to consider the implications of your decision. So first of all, do you understand, sir, what I've just said to you?
Yes, sir.
All right. And Mr. Arbor and Ms. Elliott, have you had an adequate time to discuss this decision with your client?
Yes, Your Honor.
All right. And since there will be evidence for the defense, you'll have additional time to discuss it should need be, and I don't need to know a decision, but just want to make sure that Mr. Broyhill understands the implications and that he has had ample time to consider those implications and discuss them with you. All right. Thank you. Mr. Fawcett, anything for the state?
Judge, I will alert the court on the witness list. I don't know specifically who counsel's getting ready to call, but there is a doctor listed here. To date, the state did file a reciprocal discovery motion. It's not received any discovery, and as to a doctor on here who I believe is a psychiatrist in the Department of Corrections. But that's the extent of what I'm aware of here, and I don't know if this is if this is a witness, and if so, it's today. But if it is, I'd like to bring to the court's attention. I'm not sure the parameters, what's getting ready to occur as to that witness, if he's a witness being called.
Mr. Arbor.
Yes, I can respond to that. Your Honor, Dr. Badri Hamra is a doctor working for the North Carolina Departments of Corrections. That's spelled B-A-D-R-I, for the first name Hamra, H-A-M-R-A. He works as a psychiatrist at Craven Correctional Facility. Mr. Broyhill was his patient at Craven Correctional Facility. We are not calling him to render an opinion. We're not calling him as an expert. We have not given a notice of NGRI in this case. We have not given a notice of diminished capacity in this case. However, there is state of mind to consider for the jury in the issue of premeditation and deliberation as to one of the counts. Additionally, the state has chosen, and we included Dr. Hamra in our initial witness list, the state has chosen to enter the statements of our client as evidence in this case. You have already ruled on and would certainly know our objections with respect to the statements of April 23rd, 25th, and 26th. The 26th is in evidence, and in that testimony that has been submitted to the jury, which we anticipated would be submitted to the jury by the state, there is evidence, statements made by Mr. Broyhill regarding him being depressed, regarding him hearing voices. I am not asking Dr. Hamra to render an opinion. I will not be asking him to give a diagnosis. I will only be asking him whether or not Mr. Broyhill is receiving received any medication and what the medication was for, and that would be the extent of the testimony. It goes to the elements, to the evidence, I should say, that the state has chosen to present in this case regarding Mr. Broyhill. I will not be asking him to render an opinion. I'm not tendering him as an expert, which is why I did not provide Mr. Fawcett with a curriculum vitae, and I assume that Mr. Fawcett does not want to contest that Dr. Hammer is qualified since he works for the state as a psychiatrist. It would be, I think, a different road he wouldn't want to go down for this trial. But that is all I will be asking him about, is his treatment of Mr. Broyhill and what he did. He is solely a fact witness. Premeditation and deliberation is an element of first-degree murder. The mental state of the defendant has been discussed at great length. There's clear evidence that he has attempted suicide at the time of these events. This is just to provide the jury with some understanding, because credibility has been called into question regarding our client, whether or not what he has, the state has provided in Stage 46. They were able to go out and verify a lot of things that Mr. Broyhill said by going out and bringing in witnesses to testify. We should be allowed to do the same. He told them things in his interview of the 26th. This is just in support of that information. It's not collateral because it goes to state of mind, and state of mind is an element as premeditation and deliberation. We will not be asking him to give a diagnosis. He's solely a fact witness.
All right, so you are, I've heard you say you intend to ask him about the treatment that he is providing for your client.
Not specifically, just the medication.
All right. The medications that he has prescribed for your client after, and I assume because he's with the Department of Correction that all of these prescriptions will be after April 22nd, 2013. Is that correct? All right. The medications prescribed and what those medications are for?
Yes.
Namely the illness or condition that they're used to treat?
Yes.
All right. Is he going to talk about symptoms of those illnesses?
I'm not going to ask him any questions about it. If Mr. Fawcett wants to get into it, that's fine with me.
All right. So those two. All right. Mr. Fawcett.
Judge, obviously 15A905 talks about the reciprocal responsibilities of reports of mental examinations that you intend to introduce at trial or which were prepared by a witness whom the defendant intends to call at trial when the results or reports relates to his testimony. And obviously no notices were given of all of the mental issues in 15A905 subsection C, specifically diminished capacity. And the state of mind and the issue of premeditation as to first-degree murder, that is diminished capacity. That's exactly what diminished capacity is, what Mr. Barber was mentioning. So he's going to call the doctor to the stand and then ask just what medicines after, at some point in time at Craven, I'm not sure what the point in time is, that this doctor has prescribed, which puts him in, that puts his expert opinion out there that he believes this is the right medicines for this particular person that he's treating. This sounds like an expert opinion. I mean, how else can a doctor prescribe these medicines to a patient without there being a good faith medical reason to prescribe the medicines? And then this is after the offense date. I'm not sure when the medication prescriptions start, and maybe the court maybe desires to hear this on voir dire to get an understanding of exactly the parameters here. But that's the state's observation on this case.
Mr. Arbor?
Yes. Mr. Fawcett is completely out of line and asking for a notice under 15. I know what my obligations are. If you were being offered as an expert witness, then I'd have to give him a curriculum vitae. If I had filed a notice of diminished capacity, I'd be saying I'm going to argue to the jury an affirmative defense that if they found diminished capacity on his part, they would then have to find him not guilty of a first-degree murder, and they can consider second-degree murder. But I have not filed that motion. I cannot make that argument. That's what 15A905 is about. Had I filed that, then I would be calling doctors. I didn't call a doctor for that purpose. But premeditation and deliberation goes to state of mind. It involves consideration. It involves whether someone has given thought into the consequences of the action. In this instance, we have facts that Mr. Broyhill attempted to take his life on that day. So there is an issue regarding that. The state has chosen to put in a portion of a statement that he gave, where he talks about things that involve his being depressed and his hearing voices. And I'm not asking this doctor to give a diagnosis, but we should be able to provide information just like the state did in showing that the things that Mr. Broyhill said could be proven at a later time, that there was an issue regarding their state of mind. We should be allowed to offer this evidence because it goes to the statement that he gave, that the state is relying so much on to try to convict him of murder in the first degree. I'm not going to be standing up arguing about diminished capacity. I'm going to be asking the jury about whether or not the defendant weighed the consequences of his actions, which is a legitimate argument to premeditation and deliberation. They get to consider his mental state when they're doing it. So we're not offering him to give an opinion. We're not offering him to tell his diagnosis. It's only with respect to what he did with respect to the treatment of this individual. And we're not asking him to do the other things. If I was doing that, I would have given him notice, and I would have provided him with CV. He's a fact witness. He's not an expert witness rendering an opinion in this case.
When is this witness expected? Is he the
He's
one?
here.
So he's here
He's be
today.
the next witness.
Did he prescribe these medications?
Yes.
And you're going to ask him what those medications are prescribed for.
And I'm not going to be asking him to explain.
How is that not scientific, technical, or other specialized knowledge that would assist the trier of fact to understand evidence or to determine a fact in issue where you're relying on a witness qualified as an expert by knowledge, skill, experience, training, or education? I mean, as
He's a fact witness. He's no different than a detective who comes in and says, I've got training and I've done these types of investigations. He's an individual who has, his training is, I'm a doctor, I prescribe medication. All I'm going to ask him to do, are you doctor, how are you employed? Have you given this individual, Mr. Broyhill, medications? Was he your patient? What did you give him? Basically, that's what it comes down to. I'm not asking for an opinion. He's not doing a test. He hasn't done an examination that he's going to be testifying about. This does not fall under 15A905. He's just a fact witness. He's not an expert witness. He doesn't become an expert witness unless I start asking him questions about his diagnosis. I'm not going to do that.
yes, sir.
I think 403 comes into play at some point too. I mean, this is, and I don't know what the answer, I don't know anything which is possibly getting ready to occur. And maybe the court wants to inquire further of the witness himself, but is the answer I started prescribing him whatever he prescribes on that, whatever post-offense date, and then is it, what does that medicine do? What is it? This seems either, it seems to be 403, it's not relevant, well after post-offense conduct, or it seems to be an end run around expert testimony, because I do believe a prescribing physician is an expert, and they are making a professional judgment on their education experience with the patient of a course of treatment.
I think we'll need to do a voir dire of the witness to see what the actual testimony is, and then I'll have to consider this objection further. So we will need to do that outside the presence of the jury. Go ahead and do that now if your witness is available.
Name for the court.
First name Badri, B-A-D-R-I. Last name Hamra, H-A-M-R-A.
Can you tell us, sir, how you were employed?
Department of Public Safety.
And what do you do for that department?
I'm a psychiatrist.
How long have you worked as a psychiatrist for the Department of Public Safety?
Little over 10 years.
How many patients do you deal with at any given time?
I work in different prisons, so it depends which prison it is. At the prison that is identified as Craven Correctional, I normally see about 16 patients a day.
Do you treat prisoners who are in need of psychiatric care?
Yes, sir.
Are there other types of doctors that work at the prisons who treat inmates for other medical needs?
Yes, there are medical doctors and physician assistants that treat medical problems.
But your main function is to deal only with those in need of psychiatric care?
Yes.
In the course of your work, do you recall having treated an inmate by the name of Jonathan Broyhill?
Yes, sir.
Do you see him in the courtroom here today?
Yes, sir.
Could you identify him, please, for the record?
That gentleman over there.
All right, ask the court to note he's pointing to my client seated next to Ms. Elliott in the burgundy sweater.
So noted.
As a psychiatrist, do you ever prescribe medication for an inmate if you believe that it will help them to deal with any mental health issues they may be dealing with?
Yes, sir.
Are these patients being held in custody while you are treating them?
Yes, by definition, they are in the prison.
Are you familiar with the term safekeeper?
Oh, yes.
Can you tell us what that means?
Normally, if somebody is identified as has committed a crime and is held in jail, if they cannot house him in jail for one particular reason or another, they bring them to the prison system to house them in the prison. We call them safekeepers. So it's somebody, before they are tried, they are housed in the prison system because the county cannot handle them for medical or sensitive other reasons.
To the best of your knowledge, was Mr. Broyhill someone waiting to have his case resolved in court when you treated him?
Yes, he was always a safekeeper. That's correct.
When you treated Mr. Broyhill, did you prescribe any medications for him to take to deal with his mental health issues?
Yes, I did.
Among the medications that you prescribed for Mr. Broyhill, were any of them for anxiety, depression, or psychosis?
All of the above.
Could you please tell us what medications you prescribed for Mr. Broyhill when he was your patient?
There are 4 medications given to him. One is called Effexor XR. If you want me to spell it, I will.
Yes, sir. If you would spell it for the record, please.
Effexor XR is EFFXOR, and then XR after that. EFFE, I'm sorry, EFFE, Effexor. The next one is Zoloft, ZOLOFT. The third one is Buspar, BUSPAR. And the last one is Risperdal, RISPERDAL, Risperdal.
The Effexor and Zoloft, is that for depression?
Primarily, they are for depression. They are also used in our specialty sometimes for anxiety too.
The Risperdal?
It is primarily used in this particular case as an antipsychotic.
What was the other medication?
Buspar.
And what was that for?
Normally, it's used for anxiety.
Sometimes do you have to experiment with different medications to see how a patient responds to them?
Yes, sir.
Do you sometimes start a medication for a patient and then have to change it to adjust how they respond to that medication?
Yes, we do that.
Do patients always stay at one facility while they are waiting trial as a safekeeper?
Normally, they stay extended period of time as safekeepers unless there is particular reason why they cannot be in that prison. They move to another prison. But I have seen people as safekeepers stay like a year or two or even 3 years in the same facility.
So sometimes they can move from one.
Sometimes they can, sometimes they don't.
When an inmate moves, is it your practice, when they come to you from a different facility, is it your practice to review their medical records from that different facility?
Whatever the records available at the time. There are some places where all the records goes with the inmate. Some places not all the records goes with the inmate. Because like in the hospital setting, like at Central Prison, it's a hospital setting, so they keep their records for themselves. They don't transfer it to Craven Correctional, where it is an outpatient facility. So if we request the records, we usually get a summary of what they did, not the whole extended records, because it's fairly extensive and has more than 1,000 pages sometimes. So we get a summary of what they do, yes.
Is it a recommended procedure to review that summary?
We always do, yes, sir.
Even though you review a patient's past summary, do you still make your own evaluation as to whether that patient is in need of medication?
That is my job, sir.
Did Mr. Broyhill come to you from a different facility prior to becoming your patient?
Yes, he came from Central Prison in Raleigh.
Is it your understanding that there's a hospital at that facility?
Hospital and also an outpatient setting, it's both ways.
Did you review a summary for Mr. Broyhill?
Yes, I did.
Was that consistent with your typical practice in treating any patient?
Yes.
According to that summary that you reviewed, had Mr. Broyhill been receiving psychiatric medications prior to coming to your care?
Yes, sir.
Did these records also indicate that Mr. Broyhill had been a safekeeper at Central Prison?
Yes, he was.
Has he been continuously hospitalized there for over a year prior to coming to the facility where you work?
I believe so, sir, yes.
Did your review of the medical summary that was provided indicate that he had been on psychiatric medications prior to coming into your care?
Yes, he was.
Was he still receiving those medications when he came to Craven?
They changed his medications at Central Prison. When he came to me, he was taking the medications that I named for you for a period of time, but I cannot know exactly how many months, but he was on different medications at different times.
When a patient gets transferred from one facility to another, does that patient continue to get psychiatric medications that had been prescribed for him at the previous facility?
He will be automatically on them until he sees the doctor, which is in case me, and then I make a decision whether to keep them or change them.
And then if you decide to change it at that point, you can change it.
Oh, absolutely, yes.
Is this what happened in Mr. Broyhill's case?
No, sir. He stayed on the same medications.
Did he continue to receive psychiatric medications until you were able to see him yourself?
Yes.
After you saw him, you continued him on these medications?
Yes, I did.
The ones that you previously mentioned?
Yes.
Did that continue until Mr. Broyhill left Craven Correctional Facility?
Yes, sir.
Do you know when that was?
I saw him in February, and he left, I think, the week after that. So,
Was that to come to Raleigh for his trial,
yes.
if you know? Dr. Hammer, to your knowledge and based upon the records you reviewed, is it fair to say that since his arrest, Mr. Broyhill has been held in custody as a safekeeper and has consistently been prescribed psychiatric medications for his mental health needs?
Yes, sir.
Would you prescribe these types of medications for an inmate if they didn't need it?
That will be unprofessional, sir.
In the prison system, do inmates sometimes request a psychiatric medication even though they might not suffer from a mental illness?
Sometimes that happens, yes.
Would you prescribe a medication for an inmate simply because they ask for it?
I hope not. I don't.
Would there have to be a legitimate medical reason for prescribing a patient a psychiatric medication?
That's the way it should be, yes.
No other questions?
Mr. Fawcett, do you have questions?
Doctor, when did you first see Mr. Broyhill?
I believe it was the month of July,
July of
2014.
14. All right. Have you prepared any reports in expectation of your testimony today?
I'm sorry?
Have you prepared any reports in expectation of your testimony today?
I read the records, yes.
You read the records
Yeah.
in preparation for your,
Yes, sir.
and the records would be the records from your facility and your medical records at Craven, is that right?
And whatever was available from Central Prison.
Okay.
But I must note that the available records from Central Prison were very limited. They were summary of what happened at Central Prison, not the whole record, which is very extensive.
Do you have all these records with you today, sir?
No, sir, I don't have them with me. But I think I remember them fairly good.
Should I stay as no other questions? Sure.
Okay. Anything further, Mr. Arbor? All right. Mr. Fawcett, do you wish to be heard?
Judge, yes, the state believes this is one, that it is in fact expert opinion about prescriptions of psychiatric medicines and for legitimate medical reasons and for treatment of the defendant post-arrest conduct, and has no, I mean, that's what his testimony is being proffered for. And also, I think that there's a 403, it's irrelevant, it's unfair. This expert testimony that's not being presumably offered as expert opinion with any reports and documentation in discovery for the state's preparation. I think it's clear that this, at the end of this defendant, at the end of Dr. Hammer's testimony, that he's letting the trier of fact, the jury, know that this defendant has antipsychotic, anxiety, and depression issues, at least since he's been a safekeeper, certainly under his watch, and then starting back at Central Prison, which date well after the offense date alleged in this matter. The state would ask that you exclude this proffered testimony.